Hello, this is the Kelso Report's Supreme Court Review for the October term 2011, and I'm your host, Clark Kelso. We cover the October term in 4 separate installments, covering constitutional law, commercial and civil law, government law, and criminal law. In this 3rd installment, we take a look at the major cases decided by the court in the field of government law, which includes cases involving absolute and qualified immunity, sovereign immunity, government contracts, judicial review of agency action, and immigration. Let's begin with absolute and qualified immunity. We had 4 cases this term dealing with individual immunities from liability, and the government employees won in all of the cases. The Supreme Court is very protective of government workers, and these cases show just how hard it is successfully to maintain an individual action against a government employee. First, Rayburg v. Polk. The chief investigator for a district attorney's office testified at grand jury proceedings that resulted in the plaintiff's indictment. After the indictments were dismissed, plaintiff brought an action under Section 1983 alleging that the chief investigator had conspired to present, and did present, false testimony to the grand jury. Applying well-established immunity doctrines, the Supreme Court unanimously held in Rayburg v. Polk that the chief investigator was protected by an absolute immunity from suit for testimony delivered to a grand jury. An absolute immunity protects witnesses at trial, and the court rejected the plaintiff's argument that grand jury witnesses should be treated as so-called complaining witnesses instead of as trial witnesses. The court rejected this argument because a so-called complaining witness historically did not always testify as a witness. Instead, the term referred to anyone who procured an arrest or initiated a prosecution in a practical sense. The law was clear that if a complaining witness actually did testify at trial, that witness received the same absolute immunity as other witnesses. Our second case, Ryburn v. Huff. Now, as a general matter, the Supreme Court only takes cases to deal with novel or unsettled questions of law. Every now and then, as we know, the court takes a case just to correct a mistaken decision by the lower courts. And you can often tell when that happens because the result is unanimous and per curiam. And that appears to be what happened in Ryburn v. Huff, where the court reversed a Ninth Circuit decision that had denied qualified immunity to 2 officers who had followed a mother into her home when, in response to a question about whether she had any guns in the home, she turned and ran away into the home. The officers were at the house to investigate concerns that her son may have threatened to shoot students at his high school. The officers remained in the home only 5 to 10 minutes, did not conduct a search, and did not detain the mother or son. Once they had an opportunity to talk to the parents and child, they realized the school concerns were unfounded and left. Nevertheless, the parents sued for damages under Section 1983. There was no new law here. The district court held that the officers were entitled to qualified immunity because the mother's odd behavior, combined with the information gathered at the school, could have led reasonable officers to believe that there could be weapons inside the house and that family members of the officers themselves were in danger. The Ninth Circuit had reversed, concluding that the officers' belief that they might be threatened was objectively unreasonable, and the Supreme Court took the case and reversed the Ninth. In reversing, the court explained that the Ninth Circuit should have viewed all of the facts together instead of analyzing each individual step separately, and that it should be cautious about second-guessing a police officer's assessment on the scene about the danger presented by a particular situation. Next, the scope of a police officer's qualified immunity was before the court in Messerschmitt v. Millender. The officers here had conducted a search of the plaintiff's home, this time pursuant to a warrant issued by a magistrate. The warrant authorized a search for all guns and gang-related material, in connection with an investigation of a known gang member for shooting at his ex-girlfriend with a pistol-grip sawed-off shotgun. The plaintiffs brought an action seeking to hold the officers personally liable for damages under Section 1983, alleging that the search violated the Fourth Amendment because there was not sufficient probable cause to believe the items sought pursuant to the warrant, that is, all guns and gang-related material, were evidence of a crime. The Ninth Circuit had held the warrant was invalid and that the officers were not entitled to immunity because the invalidity was so obvious that any reasonable officer would have recognized it, despite the magistrate's approval. Well, what was so obvious to the Ninth Circuit was not quite so obvious to a majority of the Supreme Court, which reversed by a 7-2 margin, with the chief writing the opinion. The fact that the warrant was issued by a magistrate certainly raises the burden on the plaintiff significantly, since the officers should be entitled to rely on the magistrate's judgment. In cases where a magistrate has issued a warrant, qualified immunity protects the officers unless it is obvious that no reasonably competent officer would have concluded that a warrant should issue. Well, as for the guns, the court reasoned that it would not have been unreasonable for an officer to conclude that there was a fair probability that sawed-off shotgun was not the only firearm the suspect owned. It would be reasonable to assume the sawed-off shotgun was illegal, and given his gang membership and willingness to kill someone, a reasonable officer could conclude that there would be additional illegal guns at the house. On the gang aspect of the warrant, although the victim had given the police information about the suspect's gang ties, and a reasonable officer could view his threat to kill her if she called the police as related to his fear of disclosure of his gang relationship. At a minimum, evidence of gang ties could easily be relevant to the prosecution of the suspect, either as direct evidence or in response to explanations by the suspect. Ultimately, the majority concluded that even if the warrant were invalid, it was not so obviously lacking in probable cause that the officers can be considered plainly incompetent for concluding otherwise. Finally, in qualified immunity, a fire department employee took 3 weeks off, ostensibly because of a work-related injury. This is Filarski versus Delia. Suspecting foul play, the department hired a private investigator who observed the employee buying construction supplies, including insulation rolls. The department believed the employee was actually working on a construction project at his home. The department hired a lawyer to conduct an administrative investigation and interview. As part of the interview, the employee admitted buying materials, but denied doing any construction work at home. The lawyer proposed verifying the employee's assertion that no work had been done by visiting the employee's home and having him produce the insulation. The employee refused, but the lawyer then secured an order from the fire chief directing the employee to produce the construction materials on the front lawn, which he did. The employee then sued the city, the fire department, and the private lawyer hired to conduct the investigation. The issue before the court was whether an individual hired by the government to do government work is prohibited from seeking qualified immunity solely because he works for the government on something other than a permanent or full-time basis. In Filarski, a unanimous Supreme Court held that the private lawyer hired by the department was entitled to the same qualified immunity as government employees for the same reasons that government employees receive such an immunity. Namely, as explained in an early Supreme Court decision, the public good can best be secured by allowing officers charged with the duty of deciding upon the rights of others to act upon their own free, unbiased convictions, uninfluenced by any apprehensions. In applying qualified immunity in Filarski, the court distinguished a 1997 decision in Richardson v. McKnight, where the court had previously held that private prison guards employed by a private prison company, which took on a long-term obligation to provide prisons to a state, were not entitled to qualified immunity. Richardson had described itself as a narrow decision involving a private firm systematically organized to assume a major lengthy administrative task with limited direct supervision by the government, undertaking that task for profit and potentially in competition with other firms. It's a pretty narrow description of the case. So in these circumstances, the court did not see the same need for qualified immunity to ensure that decision-making would be insulated from concerns about personal liability. The Richardson decision now clearly appears, after Filarski, to be limited to its unusual facts in the private prison context. Next, we have 3 cases directly involving the application of sovereign immunity in actions for damages against federal or state governments. The general rule, of course, is that a sovereign cannot be sued without its consent, and that consent ordinarily will not be implied. Usually it requires an express waiver by Congress. Our 3 cases this term nicely reinforce these basic principles. So, first, Minneci versus Pollard. Now, because of sovereign immunity, a person may sue the federal government, generally, only if the federal government has provided consent. And almost always, that's found in statutes. There is a big exception in Bivens versus 6 unknown federal narcotics agents, 1971 decision. The United States Supreme Court recognized a damages claim against the federal government for a violation of the search and seizure clause of the 4th Amendment. Although the court extended Bivens to a few other claims, over the past 3 decades the court has rejected efforts to expand Bivens to other constitutional provisions. In this term's case, Minneci versus Pollard, the Supreme Court again rejected an invitation to expand Bivens. This time rejecting a claim based on the cruel and unusual punishment clause of the 8th Amendment, arising out of alleged inadequate medical care being delivered in a privately run federal prison in California. According to the court, state tort law in California authorized adequate alternative damages actions, and since that alternative remedy existed, there was no need to recognize a Bivens claim. And that was a lopsided 8-1 decision with only Justice Ginsburg in dissent. Next, a case arising under the Privacy Act of 1974, which contains a comprehensive and detailed set of requirements for the management of confidential records held by executive branch agencies. If an agency fails to comply with those requirements in such a way as to have an adverse effect on an individual, the Act authorizes the individual to bring a civil action against the agency. Furthermore, for violations found to be intentional or willful, the United States is liable for, quote, actual damages, close quote. Well, in FAA versus Cooper, the court held that actual damages under the Privacy Act does not include damages for mental or emotional distress. The court's holding is a direct reflection of its general principle that waivers of sovereign immunity must be unmistakably clear, and that ambiguity regarding the scope of a waiver will generally be construed to preserve sovereign immunity. The history of the Privacy Act and its conceptual similarity to defamation law suggested to the majority that the phrase actual damages might mean only pecuniary damages, or in the language of defamation, special damages. In light of that ambiguity, the court applied its sovereign immunity canon of construction and held that the Act does not authorize recovery of damages for mental or emotional distress. Now, it would not surprise me at all if Congress acted to overrule this decision, since emotional distress is one of the primary types of injuries that occurs when someone's informational privacy is invaded, and private information is improperly disclosed. And since the Act already limits the damages recoverable to cases of intentional or willful violations, it seems to me unlikely that expanding the scope of damages would significantly burden the United States Treasury. We'll see if Congress acts on this anytime in the foreseeable future. Next, we have a case arising under the Family and Medical Leave Act. Subdivision D of Section 2612A1 requires employers, including state employers, to grant unpaid leave for self-care for a serious medical condition, provided that other statutory requisites are met, particularly requirements that the total amount of annual leave taken under all the Act's provisions does not exceed a stated maximum. The Supreme Court had previously held in Nevada Department of Human Resources v. Hibbs, 2003 case, that the Act constitutionally abrogated state immunity from damage suits with respect to a different subdivision dealing with so-called family leave, not self-leave, family leave for a serious medical condition suffered by family members. The holding in Hibbs was based on evidence that states discriminated on the basis of gender in granting and administering family leave policies. And so Congress had power under the 14th Amendment to abrogate state sovereign immunity. In contrast, there was no evidence that states had discriminated on the basis of gender or any other protected basis in granting and administering self-care leave policies. Absent that evidence, there was no basis for Congress to invoke its powers under Section 5 of the 14th Amendment. And the Supreme Court in Coleman v. Court of Appeals of Maryland, with Justice Kennedy writing for a four-justice plurality, held that the self-care provision of the Family and Medical Leave Act could not constitutionally impose damages upon a state for its violation. Justice Scalia concurred separately to make up the 5 votes, but he would have gone much further by even overruling Hibbs and holding that none of the Family and Medical Leave Act provisions can be applied against a state, because the Act goes far beyond anything that directly constitutes a violation of the 14th Amendment. Well, our next case involves the topic of the interpretation of government contracts and the connection between contract terms and the government's appropriations power. The Indian Self-Determination and Education Assistance Act, ISDA, directs the Secretary of the Interior to enter into contracts with willing tribes, pursuant to which those tribes will provide services, such as education and law enforcement, that otherwise would have been provided by the federal government. ISDA mandates that the Secretary shall pay the full amount of, quote, contract support costs, close quote, incurred by tribes in performing their contracts, quote, subject to appropriation, close quote. Well, Congress appropriated in a lump sum sufficient funds to pay in full any individual contractor's contract support costs, but not enough funds to cover the aggregate amount due all of the contractors. So the question in Salazar versus Ramon Navajo chapter was whether the lump sum appropriation triggered the contractual obligation to pay full support costs to every individual contractor, even though the amount of the lump sum appropriation was insufficient to pay all of those aggregated costs. In a 5-4 decision, the court held that, consistent with long-standing principles of government contract law, the government must pay each tribe's contract support costs in full because the lump sum appropriation triggered the contractual obligation to pay. The fact that the agency may run out of money in that appropriation line at some point does not relieve the agency of its contractual obligation to pay. If they're going to do that, they're going to have to redraft those contracts. Now, our next 4 cases involve the question of how courts review agency action, a question usually thought about in terms of administrative law. But it actually is also a question of sovereign immunity, because as a general matter, judicial review of agency action is governed by statutes that waive the government's sovereign immunity. And these statutes also generally provide the appropriate standard of review. In Elgin versus Department of the Treasury, the Supreme Court resolved the question of whether the Civil Service Reform Act of 1978 provides the exclusive procedure for obtaining judicial review when a qualifying federal employee challenges an adverse employment action by arguing that a federal statute is unconstitutional. The problem arose in a case where the defendant was terminated because he had knowingly and willfully failed to register for the Military Selective Service, which, pursuant to statute, made him unqualified for his position. He challenged the statute on constitutional grounds. When the ALJ assigned the case under the Civil Service Reform Act held that he had no power to declare a statute unconstitutional, the employee dismissed his appeal and filed an original action in the district court. Well, in order to retain a unitary review system, the Supreme Court held that Congress intended to establish in the Civil Service Reform Act of 1978 the exclusive procedure for reviewing adverse employment actions. With respect to constitutional claims, the ALJ is supposed to permit the claim to be made along with any applicable record, so that the Court of Appeals for the Federal Circuit, which ultimately reviews adverse actions under the Act, has a basis for resolving the constitutional claim. It's clear that the Federal Circuit, an Article III court, has power to strike down an unconstitutional statute. Next, we look at judicial review of actions by the Environmental Protection Agency. Now, when the Environmental Protection Agency determines that there is a violation of the Clean Water Act, it can either issue a compliance order or it can initiate an enforcement action. In Sackett v. EPA, the agency determined that the owners of a residential lot were in violation of the Act because, in the agency's view, there were navigable waters on the property, and a construction project on the property would discharge pollutants into those waters. The property owners received a compliance order from the EPA which stated that their residential lot contained navigable waters and their construction project violated the Act. The property owners filed an action in district court challenging the compliance order under the Administrative Procedure Act. The government remarkably argued that there was no jurisdiction under the APA, either because the APA did not apply to a pre-enforcement compliance order, since that arguably was not final agency action, or because the Clean Water Act's provisions preclude judicial review of compliance orders. The District Court and Ninth Circuit agreed with the government and dismissed for lack of jurisdiction. But the Supreme Court unanimously reversed. The court first concluded that a compliance order satisfied the standards for being final agency action, and such an order was therefore subject to review under the terms of the APA. Second, the court held that under the Clean Water Act, it did not expressly or impliedly preclude review of compliance orders under the APA. The government's arguments to the contrary were pretty weak, essentially amounting to assertions that the targets of compliance orders needed to wait for an enforcement action before securing judicial review of EPA's decision-making. But as Justice Scalia noted in closing the opinion, there's no reason to think that the Clean Water Act was uniquely designed to enable the strong arming of regulated parties into, quote, voluntary compliance, close quote, without the opportunity for judicial review. Our next APA case, in an 8-1 decision in Match E.B. Nash Shewish Band of Potawatomi Indians versus Patchak, the Supreme Court held that a neighbor to Indian property taken into trust by the United States for Indian gaming uses who wished to challenge the United States' title to the property, not for purposes of asserting his own title, and solely for purposes of defeating the intended use of the property, has prudential standing under the Administrative Procedure Act to challenge the decision of the Secretary of the Interior to take the property in trust. The case involved the technical interaction of the jurisdictional provisions of the APA, the Quiet Title Act, and an Indian lands exception to the Quiet Title Act. The District Court had interpreted these statutes such that there was no jurisdiction to review the Secretary's decision. The Supreme Court's holding harmonizes the statutes so that the Secretary's decision can be reviewed under the Administrative Procedure Act. at least in cases where the plaintiff is not actually seeking to assert title in the property. Finally, we take a look at judicial review in the context of the Medicaid program. Sometimes the critical facts that set the stage for an appeal change while the appeal is pending. And if the changed circumstances don't moot out the dispute, they may at least change the legal issue to be resolved. That is what happened in Douglas v. Independent Living Center of Southern California. The state of California had adopted a new plan for its Medicaid program, which called for significant cuts in payments to providers. For a state plan to be legally effective, it must be submitted to the federal agency with jurisdiction over Medicaid, which is the Center for Medicare and Medicaid Services, otherwise known as CMS. CMS must approve the plan for it to be effective. In California, providers and beneficiaries didn't wait for CMS to act, and they sued to enjoin the plan shortly after it was adopted by the state. The plaintiffs asserted that they had standing to challenge the state plan under the Supremacy Clause, with the substantive basis for their claim being that the state plan was inconsistent with the Medicaid statute's requirements for adequate reimbursements. The Ninth Circuit affirmed preliminary injunctions against implementation of the state's plan. The Supreme Court had granted cert to decide whether the plaintiffs could mount a Supremacy Clause challenge to the state plan, absent express statutory authorization for such a challenge. However, after oral argument before the court, CMS approved several of the state's amendments, and the state then withdrew the remainder. In these circumstances, a 5-4 majority of the court decided that the legal issue had now changed to whether the providers and beneficiaries had standing under the Supremacy Clause to challenge a state plan that had been approved by CMS. Framing the issue in this way dramatically alters the litigation context, since it appears that if there is to be review of CMS's decision, that review should be pursuant to the deferential review processes of the Administrative Procedure Act, rather than a direct action filed in district court. But the Supreme Court did not resolve that question in this opinion, preferring to remand to the Ninth Circuit to give that court the chance in the first instance to consider this new standing issue. Well, the court had 4 straight immigration cases this term. First in Udelang v. Holder, the United States Supreme Court unanimously held that the Board of Immigration Appeals acted arbitrarily and capriciously under the Administrative Procedure Act in adopting a comparable grounds rule to evaluate the merits of deportation cases using standards found in Section 212C, which apply in exclusion cases. According to the court, the BIA's rule has the effect of hinging a deportable alien's eligibility for discretionary relief on the chance correspondence between statutory categories that were developed along slightly different lines for determining discretionary relief for excludable aliens. Unable to discern a reason for the rule adopted by the BIA, the court concluded that the BIA's comparable grounds rule is unmoored from the purposes and concerns of the immigration laws. It allows an irrelevant comparison between statutory provisions to govern a matter of the utmost importance, whether lawful resident aliens with long-standing ties to this country may stay here. Next, the Ninth Circuit got an affirmance in Kawashima v. Holder, an immigration law case raising the issue of whether a resident alien's conviction for willfully making a false tax return constitutes an aggravated felony under the immigration laws for which the alien can be deported. The Ninth Circuit had agreed with the Board of Immigration Appeals that a conviction for willfully making and filing a false tax return in which the government's revenue loss exceeds $10,000 does indeed constitute a crime involving fraud or deceit and is therefore an aggravated felony for immigration purposes. The Supreme Court agrees with the Ninth Circuit and affirmed the case. That's one of those where it's not exactly clear why the Supreme Court granted review. Next, in 1996, Congress enacted, of course, the Illegal Immigration Reform and Immigrant Responsibility Act, IRERA. and one of its provisions effectively precluded foreign travel by lawful permanent residents who had been convicted of certain crimes. Under IRERA, such aliens on return from a trip abroad, however brief, may be permanently removed from the United States. In Vartalis versus Holder, the court faced an alien who had been convicted prior to the enactment of IRERA, but who had traveled abroad after the enactment of IRERA and then returned to the United States. So the issue for the court was whether to apply the pre-IRERA law to the case or the post-IRERA law. Congress did not speak to this retroactivity issue in the legislation, and the court held that the new provision precluding foreign travel attached a new disability, that is, denial of re-entry, in respect to past events, that is, the alien's pre-IRERA offense. In light of the court's general reluctance to apply legislation retroactively, the court held that the travel bar did not apply in the situation presented. Accordingly, the alien's brief travel abroad should have been analyzed under pre-IRERA law, which in general permitted innocent casual travel. The court remanded to the Second Circuit to apply the correct law to the case. Now, Chevron deference was the overriding factor in the Supreme Court's immigration decision in Holder versus Gutierrez, and it accounts for the court's unanimous judgment in the case. The issue here was a technical one, whether a child should have imputed to him or her the number of years a parent has resided in the United States as a lawful permanent resident. The background here is that an immigration statute authorizes the Attorney General to cancel the removal of an alien from the United States so long as the alien satisfies certain criteria. One of those criteria relates to the length of time an alien has lawfully resided in the U.S., and another to the length of time he has held permanent resident status here. The Board of Immigration Appeals concluded that an alien living in this country as a child must meet those requirements on his own, without counting a parent's years of residence or immigration status. The Ninth Circuit had reversed, noting that the Immigration and Naturalization Service had a general policy prioritizing familial relations, and the board had in other contexts indicated a willingness to make imputations from a parent to a child. Well, citing Chevron deference as its primary justification, the Supreme Court unanimously held that the BIA's approach was based on a permissible construction of the statute and therefore should be enforced by the courts. Well, we close this installment with two essentially miscellaneous decisions. The first involving navigability. Now, one of the attributes of state sovereignty, and a legal holdover from English common law, has been that a state holds title to the riverbeds under navigable waters within its jurisdiction. Under the so-called equal footing doctrine, when a state entered the Union, it gained title within its borders to the beds of waters then navigable or tidally influenced, subject only to the paramount power of the United States to control such waters for purposes of navigation in interstate and foreign commerce. By the end of the 19th century, the rule had developed that navigability meant navigability in fact. To be navigable in fact, a river must be used in its ordinary condition as a highway for commerce over which trade and travel are or may be conducted in the customary modes of trade and travel on water. The Supreme Court has historically assessed navigability on a segment-by-segment basis. Well, in the case decided this term, PPL Montana versus Montana, a dispute arose between the state and the owners of a hydroelectric power plant regarding ownership of the riverbeds beneath the power plant. The Montana Supreme Court ignored the segment-by-segment approach and held that because the Missouri River in general is a navigable waterway, all segments of the river were navigable, and title in the riverbed thus belonged to the state. It imposed $41 million in damages for unpaid rent over a 7-year period. The United States Supreme Court unanimously reversed. When analyzed segment by segment, it was clear the hydroelectric plants were located on portions of the river that were not navigable because of the rapid drops in altitude and the presence of waterfalls and rapids, precisely the features that made the hydroelectric plants feasible. As Justice Kennedy noted for the unanimous court, a state may not enlarge what actually passed to the state at the time of her admission by trying to adopt a novel, retroactive rule for determining navigability. Next, a case involving Social Security benefits. According to the Social Security Administration, survivors' benefits to a person's biological children are available only if the children qualify for inheritance from the decedent under state intestacy laws, or satisfy one of the statutory alternatives to that general requirement. Well, the children in this case were conceived by in vitro fertilization 9 months after the father's death, and they were born another 9 months later. Under the applicable Florida law, posthumously conceived children do not qualify for inheritance through intestate succession. The children argued that the only requirement for qualification for benefits should be that they are the biological offspring. Although the statutory issue was not free from alternative interpretations, the Supreme Court unanimously concluded in Estrue v. Capado that the Social Security Administration's reading of the statute was better attuned to the statute's text, and it's designed to benefit primarily those supported by the deceased wage earner in his or her lifetime. Moreover, that long-standing interpretation was entitled to Chevron deference, which again is what accounts, I think, for a unanimous result in that case. Well, that's it for our cases involving government law. Hope you enjoyed the review. Hope to see you next time for our review of the court's decisions involving criminal law. This is the Kelso Report. Have a great day in the law.